Welcome back to the channel and thank you for watching. I'm a barrister who helps you understand law. I've seen a number of comments which, to be quite honest, have surprised me, so I thought I would address those in this video. It was in response to Elaine Brederhoff's comments to the jury when I said she might well be in serious trouble, but I'm going to come back to that again in a moment. So the comments are along the lines of people thinking that lawyers were the only ones that were able to lie on behalf of their client, whether to the court, the judge or the jury and so on. So I have to be absolutely clear about this and say lawyers cannot and must not, under any circumstances whatsoever, lie or even mislead recklessly or otherwise the jury, the judge or the court, or in fact anyone else in the courtroom, and in fact anyone at all. So barristers, solicitors, lawyers, attorneys cannot and must not mislead anybody, much less in court. In fact, most jurisdictions will have a set of rules by which every lawyer must abide, and in England and Wales, for the Bar of England and Wales, that is contained within the BSB, the Bar Standards Board's handbook, which contains a code of conduct. It used to be called the Code of Conduct. Sometimes it's still referred to as the Code of Conduct, but now it's within the BSB handbook, as we call it. Within that, there are a number of duties, and the one that I'll draw your attention to here is core duty number 1. And that is that you must not mislead the court, even if that is recklessly, and it even extends to allowing the court to be misled. Even if, for example, your opponent is not aware of a new authority which you are aware of, and without that new authority, the court would be misled. But if that new authority is in your opponent's favour, but they're not aware of it, but you keep quiet, that means you, by withholding this information, are either intentionally or recklessly misleading the court because you are not ensuring that the court has before it all of the accurate and up-to-date information. So this core duty number 1, not misleading the court, is absolutely fundamental. There are some caveats to that which play in with the other core duties of a barrister. So for example, core duty 2, we must at all times act in our client's best interests, but not if that means misleading the court. But then also we have a duty of confidentiality to our client. That's in our core duty 6. Now, our duty to the court would not override our duty of confidentiality. However, in the circumstances that we cannot correct the position with the court so that the court is not misled and the client doesn't allow us to bring that information into court, we must withdraw from the case. In other words, we are not allowed to mislead the court just because it's in our client's best interests and our client doesn't allow us to tell the court the truth, much less lie to the court knowingly and deliberately, or even recklessly. Remember, recklessly is to accept or to understand or to know that there is a risk that the court might be misled and to continue on anyway. So, taking this to Elaine Brederhoff, if she knew that Amber had not made those payments herself and she made that statement to the jury, then she would be knowingly misleading the jury. That is against all the rules, and lawyers are not permitted to lie to the court, the judge, the jury, witnesses and so on. And if that being the case, then she's lied to the jury and she's not allowed to do that. If, on the other hand, she just believed or thought that it's possible that Amber hasn't paid these fees over, perhaps because she's aware of the insurance policy being in place and that it's most likely that the insurance would have paid these fees, then without inquiring as to the truth of that matter, then making the statement to the jury would be reckless. It would be recklessly misleading the jury, which is equally prohibited, because misleading the judge, the jury, the court can be deliberate, can be reckless, and both are against the rules. So moreover, I wanted to address, just in case anyone was in any doubt whatsoever, these comments left aside that video, because many people seem to believe that lawyers are permitted to bend the truth or outright lie in court in order to assist their client in delivering those arguments to the jury. And that is simply not the case. So just to run through that once more, if a client were to tell you something that you then know to be true, you cannot represent or even ask a question to a witness that you know the answer will mislead the court. So if you ask a witness a question and you know what the answer is going to be, and you know that that is contrary to the truth because your client told you, you cannot ask that question. Just like if a defendant has admitted the crime to you, you cannot then suggest to the court that they didn't do it, or they weren't there, or it wasn't them, or even that it was someone else. Because even if you are quite careful with how you do that, you are recklessly misleading the court. The court, of course, including the jury. So in those situations where your defendant has admitted that they committed this crime, the only thing you can do is test the strength of the evidence. You can test the reliability of the evidence, the credibility, and ultimately make a speech based around those tests and not suggesting that your client, your defendant, didn't do it. So I hope that's cleared it up. I hope everyone now understands that lawyers are beholden to the absolute truth, which is why this could be such a very serious issue for Elaine Brederhoft if she has misled the jury by knowing that the insurance company has paid these fees and not Amber Heard when she made that statement to the jury. I hope you found that interesting. Please do like the video and subscribe. And as always, thank you for watching.